Good morning,
Good morning.
Council. This is the second case for our docket here with the Kansas Court of Appeals today. I am joined by Judge Sarah Warner, who joined our court in 2019, and also by Judge Leslie Ann Isherwood, who joined our court earlier this year. And I have the honor of being the presiding judge today. My name is Kim Schroeder, and I have served on this court since 2013. My primary job will be to act as a timekeeper and kind of keep track of where folks are in the process of their argument. This matter is set for 15 minutes on each side. I would ask, I neglected in the earlier case, I would ask the appellant to give a short set of facts, since this case is being recorded on YouTube and you are now part of the YouTube history, so that anyone who may be watching this case would have a short understanding of the factual issues arising, recognizing, counsel, that we have read the briefs and we know the facts, but for those who may be viewing it, it might be handy. So with that, I think Mr. Smith, you're the appellant.
Yes, Your Honor. Thank you.
All right. Would you announce your appearances for the record?
Sure. May it please the court, my name is Ted Smith with the Kansas Department of Revenue, appearing as an appellant in this matter. I would reserve 3 minutes of rebuttal.
And may it please the court, the petitioner and appellee, Ms. Mitchell, appears by and through counsel Jay Norton.
Thank you, counsel. Mr. Smith, you may proceed.
Very good. Thank you, Your Honor. I'll begin just with the citation of the real basic high-level facts of this case. This is a matter, I believe, of area of law. The parties pretty much agreed on the facts at the district court level. There's not much dispute. The issue today is primarily a legal one. The case involves a driver's license suspension. The Department of Revenue is attempting to suspend the license of the appellee, Miss Amanda Mitchell, because she was arrested for DUI back in June of 2019 after being stopped for speeding. What happened is that Miss Mitchell, the appellee, was arrested for DUI, and she was presented a statutorily required notice, implied consent advisory, that was presented to her. And after being read, she was asked to submit to an evidentiary breath test. She refused, and the officer forwarded that notice to us, the Department of Revenue, and we initiated suspension proceedings. During this time, her license suspension was stayed pending review by the court administrative hearing officer. An administrative hearing was conducted where that hearing officer considered elements set out in statute for whether or not agency action should be affirmed or not. The administrative hearing officer affirmed agency action, finding that the officer substantially complied with providing required notices. The matter was appealed into the district court, and at the district court level, the matter is considered de novo, and the parties started from scratch, essentially, in making arguments to that court. In that context, the review of the district court's a little broader in that it can now incorporate constitutional issues or concerns. During this time, the licensee, Ms. Mitchell's driving privileges continued to remain valid, and any suspension was stayed pending that review. The parties submitted the matter on stipulated facts, more or less, and legal argument was made. This Department of Revenue maintains that the officer provided the required notices word for word that were required by statute, and that satisfied the statute, that satisfied any constitutional requirement. The district court basically opined that although the arresting officer provided the statutorily required advisories word for word, that he should have done better, that there should have been more specificity as it related to the possible outcome to the driver whether or not she refused or failed a breath test. The Department of Revenue disagrees with that position, and that's why we've appealed to this court asking for review of the district court's finding. You know, in making this argument to the court, I go back to the petition filed by the licensee at the district court level. And primarily their basis is that the notices provided were incorrect, illegal, and improper. And I think that's a good way to break down a review of the current statutory framework and a review of this issue. Because when you ask, were they illegal? Were they incorrect? You know, I don't believe it's disputed that the statute provides advisories to be given, that they were provided word for word, and that in fact, as I cite out in my brief, there are cases where when an officer may go beyond or further than what the implied consent advisories require, that also jeopardizes the state's ability to suspend the license. So we instruct our officers to try to stick with the statutory advisories prescribed by the legislature. So we believe that they are correct in this sense. You know, then you look at it in a framework, well, are they illegal? Well, the district court's review set out in KSA 8-1020 is also under the Kansas Judicial Review Act. And there are provisions in there about the constitutionality or the appropriateness of agency action upon review. And I don't believe it's been articulated very well what exactly the constitutional issue here is. Is it an issue of procedural due process? Well, the licensee was given notice. They were saying we threatened agency action. We stayed agency action. We gave them an agency action review where they could subpoena witnesses. They could present argument. Not only that, we gave them a district court review, de novo, a broader constitutional analysis, all while the license is being stayed. Suspension is being stayed. We would argue the procedural due process has been not violated here.
Counsel, wasn't the issue by the district court over the fact the notice said that her license could be suspended from 30 days to 1 year? And in reality, upon a refusal, it's just an absolute 1 year?
Well, I mean, yes, there's a range, and that was provided. So
I understand it's provided, but the range doesn't apply to this individual under the facts of the case. Is that right?
No, because we don't know what the outcome of this would have been. We don't know whether she would have agreed to and passed a breath test. We don't know if she would have.
Wait a second. If she agreed to and passed a test, there's no suspension period.
Correct.
So then you're saying if she agreed to it and failed the test, then her suspension would be how long?
That depends. That's a big point of my brief and argument to the court, is that depending on her age, depending on her breath alcohol provided, it could have been a year, it could have been 30 days.
And then if she refused, it's an absolute 1 year.
Arguably. I mean, the thing is that in the state of Kansas, after 90 days, you can modify that suspension to a limited ignition interlock. And that's sort of the Goldilocks problem.
Counsel, does that possible modification change the fact that a suspension in and of itself that is based on a refusal is a 1 year suspension?
The 1 year suspension is imposed automatically in all refusal cases. And that's imposed whether it's a first occurrence or a fifth occurrence. What I'm trying to point out that there is still some variability. And the problem, the risk we hear is how far, and we'll get into my improper argument later, but the thing is that's a policy decision the legislature's made. How specific do we have to get in these advisories in order to basically take lawful action?
I'm curious, what do you think we make of the legislature's subsequent policy decision about that they'd already made, but that went into effect a month later, that said that we really need to separate these out, that we need to give separate notices with regard to refusal consequences and failure consequences?
I think that was a really good policy decision and direction to go, but I don't think that has any legal significance here because this court is confronted with, did the officer substantially comply with the statute? And what Mr. Norton and Ms. Mitchell are asking this court to do is, hey, law enforcement officer, you have to make some decisions on the fly that constitutional scholars struggle with. And the concept here also is that she was asked to submit to a breath test and she refused. And we all know that under Birchfield, the issues regarding breath testing. So again, we get back to this illegal. And the third issue I look at it is the Fourth Amendment, privacy issue. And again, under Birchfield, when you're dealing with breath tests, once you make the arrest, that basically justifies the breath test request. Now, finally, I'll move into the third part, which is sort of improper. And getting back to this discussion about refusal and how granular we need to be, at the time that Judge Carpenter was considering this, there were two Court of Appeals opinions, both ended up being unpublished, that were considered and argued by the parties to the court. And I think they're referenced in our briefs. One case was Gross, and another case I think Judge Schrader was involved in was Creasy versus Kansas Department of Revenue at the Court of Appeals. And in those cases, they were arguing about 2013 versions of the implied consent, I believe, arguing whether evidentiary test was necessary to make those advisories sufficiently clear. I guess there was some argument at the time between a PBT and an evidentiary breath test, and that creating some confusion about whether this is a second, third, or fourth. The Gross Court said, well, hey, the advisories are not sufficient. And the Creasy Court of Appeals panel said they were sufficient. They complied with the statute. Creasy was appealed, and the Kansas Supreme Court reversed on other grounds. But on this issue, they agreed with the Creasy Court of Appeals panel and said the essentials of the statute are basically about following what the statutory requirements are. So, based on all that, Your Honors, we would respectfully ask that the court consider reversing agency action here. Like I point out, a court can always review some kind of requirement or notice provisions provided by the legislature, and they can always be improved upon. They can always be iterated. In this case, yeah, the next year they were iterated on again, and the instructions were made more clear. But look at it from the converse perspective. A month or two later, the advisories are modified and they make a difference between the refusal and failure. Well, what happens if someone's first offense submitting to a chemical test fails, but they blow over 1.5? Now they say, well, why didn't the notices provide me with better instruction about possible outcomes? And the question for this court is, how granular does the legislative body have to be in providing these notices, which, as I put forward in the brief, are really not statutorily required. They're just basically best practices that have been encouraged by our Kansas Supreme Court in going back to the 80s or 70s in Standish versus Kansas Department of Revenue. Based on all that, we would respectfully ask that the court reverse the district court.
Thank you, Mr. Smith. Mr. Norton, you have your opportunity to respond.
Thank you again. I'm Jay Norton, and I represent Ms. Mitchell, the petitioner in this case. The issue here really begs the question of, why do we give any notice at all to drivers? What is the purpose of this procedure? Why don't police officers just bring a driver down to the station and say, this is a breath test machine, will you blow into it? I'm asking this court to take a step back, take a look at the whole picture here, look at the whole statutory scheme and its purpose. What is the reason for this procedure? There is a reason that Kansas, as well as I believe all other 50 states, require that notice be given to DUI suspects in this situation. And in Kansas, it's both oral and written notice. The statute,
Counsel, but before you go down that road, I was wondering, just for my benefit, if you could articulate the constitutional basis for your argument.
well, the constitutional basis for my argument is it's really twofold. Number one, the reason that we provide notice in these situations is that the decision of whether to consent to or refuse a test implicates important rights, both Fourth Amendment rights and property rights. We know that a request for a test is a request for a search subject to the strictures of the Fourth Amendment. That's a fundamental constitutional right, and any waiver of that right or invocation of that right has to be made knowingly, voluntarily, and intelligently. So there is the Fourth Amendment constitutional issue. There's also a constitutional issue with respect to property rights, and appellate courts in Kansas, at least, have been reluctant to declare precisely what the property interest, the nature of the property interest in a driver's license is. But it's pretty clear from the case law that there may not be a fundamental natural right to drive a car, but once a license is issued, that there is at least an important right to retain possession of it. And I would submit that there is, in fact, a fundamental natural right to be free of erroneous deprivations of property and a fundamental right to notice of the intent of the state to take a property interest away.
And counsel, so bringing us back to the constitutional question, am I understanding that you are framing this as a right that arises under substantive due process, or is it something that arises elsewhere?
I believe that it arises under substantive due process and procedural due process.
And in terms of the procedural due process, she received notice and an opportunity to challenge that proceeding, right?
Well, our issue is that she did not receive notice because the testing notice that was given doesn't provide notice at all. It does not notify her of the potential consequences to her driver's license. That the notice that was given to her was wrong. And even if you want to say that the requirement to provide notices doesn't emanate from the Constitution, which I would disagree with, but if you want to say, well, it's just a legislative matter of grace, or it was judicially created or something like that, if you're going to provide notice, then the notice has to be correct. And this notice was completely, flatly wrong, which is something I...
And counsel, why was it wrong?
So, my position is that that KSA 1001 subsection C is not just vague or obscure or difficult to understand, that it is flat wrong. What it says is, if a person refuses a test or if a person fails a test, driving privileges will be suspended at least 30 days and up to 1 year. And there's 3 reasons why that is wrong. Number one, neither of the potential penalties advised of in that notice actually apply to a refusal. If a person refuses a test, they will not be, under any circumstances, suspended for 30 days. And if a person refuses that test, they will not be, under any circumstances, suspended for up to 1 year. It will be the entirety of 1 year. If the notice said up to and including 1 year, that would be closer. I would still submit that it's inaccurate and grossly misleading. In addition, this notice gives the impression, and I argue literally states, that whether you refuse or fail, the range of suspension is the same, when that is not true. There's vastly different outcomes, whether a person refuses a test or submits to and fails a test. And number three, the impression that there is a range at all is completely incorrect. That there could be a potential suspension of anywhere from 30 days up to 1 year gives the impression that there's some range and there's some subjective determination that some judge somewhere down the road is going to look at this case and say, well, this person is a good person, they've never been in trouble before, they have a clear driving record, they've otherwise been an upstanding member of the community, I'm going to give them the minimum. Or this is this guy's 10th DUI, I'm going to give him the maximum. None of that is true. None of that happens. There is no range. There is no discretion. There is no subjective determination. And this notice is wrong on all those fronts.
Counsel, I agree with you that the notice could have been clearer, right? And probably, in an ideal world would have been clearer. And that's what the legislature decided a little bit later than that. But my question is this. Was the actual statement incorrect? That is, that if you refuse or fail a breath test, this is the range of suspension possibilities that you face.
Yes, I believe that it's incorrect. Number one, of course, there is no range. But number two, the range that it gives does not include the actual consequence, which is an entire 1 year suspension. That is not communicated. If you look at what they did 24 days after this situation, when they changed it in 2019, it says, if you refuse a test, your driving privileges will be suspended for a period of 1 year. That's all you have to say. But this doesn't say anything close to that. And there could be a notice that says, if you refuse a test, you'll be suspended somewhere between 4 months and 400 years. That would be a range, and that would include the actual consequence. But of course, that would be grossly misleading and inaccurate, I would submit, to the point that it's a worthless notice.
Counsel, what level of detail is constitutionally required? So, is it necessary to, if it's necessary to break it down and say this is the consequence for a refusal, and this is a potential consequence for a failure of a test, do you then say, but there are other possibilities, as your opposing counsel has pointed out, about potentially mitigating those suspension durations?
Well, there is no mitigation. If you refuse a test, it's a 1 year suspension. Whether you're 16 years old, whether you're 65 years old, whether it's your first DUI or it's your 15th DUI, there is no mitigation. It's a 1 year suspension. There is a provision now that says you can apply for a limited restricted driving privilege. That does not change the 1 year suspension. That just allows you a certain limited privilege during the period of that suspension. And the suspension is on your driving record. And if a person fails a test, there are certain factors that can influence whether it's the 30-day suspension or it's a 1 year suspension. As far as the level of detail, I think all that it needs to say is what it says, which is that if you refuse a test, your driving privileges will be suspended for 1 year. And if you fail a test, your driving privileges will be suspended for 30 days if it's under 0.15 and you don't have a prior occurrence, and 1 year if it's over a 0.15 or you do have a prior occurrence. That's all it needs to say. That's what it said prior to this 2018 version, and it's more or less what it says now. I think it could be better, of course. I think that we should be providing people the information necessary for them to make an informed decision, which is what the case law says. And the case law says that people should be advised of these specific consequences to their driver's license. And, this is a notice statute. In the title of KSA 81001, it says duty to provide notice to drivers. If you look at the DC 70 form, which was handed to Miss Mitchell and which is read from by the trooper in this case, at the very top in bold letters, it says testing notices. And in the language of the statute, it says they shall provide oral and written notice. And there's a reason that we give people notice. And that's because before the government can extinguish a property right, take a property right, you have to be given notice and an opportunity to be heard. Opportunity to be heard is not an issue here, but the notice is. They have to tell you, here's what's going to happen to your property if you make this decision or behave this certain way, if these certain conditions.
Counsel, I feel, and maybe I'm parsing hairs here, maybe we're just talking past each other, but I feel like those are two different kinds of notices, right? That from a procedural due process standpoint, you have to have notice that of an opportunity to discuss this point. So if the court's going to hold a hearing on it, or if there's going to be an administrative hearing on the suspension issue, you have to be provided notice of that. But what you're talking about in terms of notice, I think, is different from that, right? You're talking about the notice, the substantive legality of the notices themselves with regard to the consequences. Is that correct?
That is what I was talking about. I believe that under a due process analysis, you have to, if you're going to give information, it has to be accurate information. That to warn or advise of one set of consequences and then impose a different set of consequences, I believe violates due process, both procedurally and substantively.
Thank you. I think that answers my question.
There's the reason that we give notices in these situations is at least twofold. One is to make sure that a person makes an informed decision about whether to submit to testing. That is, that they knowingly and intelligently either invoke or waive their Fourth Amendment rights. And two, so that they are put on notice of the consequences to their driver's license of refusing. Because one, I believe due process does require a notice of the actual consequence. It doesn't have to be granular or super specific, but a warning of the actual consequence that a person is facing is required. And B, all of the case law says we want to encourage people to submit to this test. That is the purpose of the statute here, is to encourage people to take the test. And this statute fails in all regards. The Department of Revenue's argument is that all that matters is that the officer, or the trooper in this case, reads the language from the statute, or that the language mirrors the statute, even if that language is wrong. The shortfall here is not on the part of the trooper. The shortfall in this case is on the part of the legislature that drafted and enacted this purported notice. The case law says that the purpose of the implied consent notices, or now what they call the testing notices, is to coerce people to take a test, to just short of physical coercion, get people to submit to this test under the threat of harsher penalties for refusing. And this statute fails to fulfill that purpose of the statutory scheme, which is to encourage people to submit to a test. When they tell you that whether you refuse a test or you fail a test, here's what the range is going to be. And it doesn't indicate anywhere that there's going to be harsher penalties for refusing a test. It fails to fulfill the purpose of the statute. The reason we want to encourage people to take the test is so that we can determine whether they're over the legal limit or not. Because we want to determine, because one, that makes it easier to prosecute them. If there's a breath test that's over the legal limit, that makes that matter a lot simpler. And two, from the administrative point of view, we want to determine who is a dangerous driver and who is not. And the breath test and other forms of testing is the quickest, most efficient way to determine who is a dangerous driver, who is not, so that they can be removed from the road. And this advisory actually does the opposite, which is that it conflates both the refusal or failing a test. And why would a person consent to a test under these situations when they're advised that the range of suspension is the same, whether they submit to the test or they refuse a test? Even the most liberal construction of this notice can't change the fact that it's wrong, that the information in it is wrong. And I said this in my brief, but I think, it bears repeating that under any common understanding of the English language or sentence structure, that sentence reads as, if you refuse a test, your driving privileges will be suspended from at least 30 days up to 1 year, neither one of which actually applies in the situation of a refusal. And to the liberal construction argument,
Counsel, I've allowed you to go a little longer, so
Oh.
I'd ask you to wrap it up.
okay, well, I'm sorry, Your Honor.
You're fine. You're
I'm
fine.
not keeping track of the time.
But
I think I've made the points that I want to make, and I appreciate your time today. I would ask that you affirm the district court judge in reversing the suspension.
thank you. Mr. Smith, rebuttal?
Thank you, Your Honor. Thank you, Jay. Basically, we believe the district court erred. At the time it was being argued, there were two Court of Appeals cases going through the court, Gross and Creasy. Those decisions were contrary to each other, and they were appealed to the Supreme Court. And there, the Supreme Court ruled at Creasy that the implied consent advisories were substantially complied with. That logic, that stare decisis, was not acknowledged by the district court, and we believe it was binding on the district court based on the facts at hand.
Counsel, do you agree that with your opposing counsel's statement that the statutory advisory is incorrect?
No, I believe that giving someone a range doesn't mean that we're not going to suspend you for up to 1 year. It could always be better drafted. And that's the slippery slope I'm asking this court to avoid. Because if the court basically affirms the district court's decision, we're going to be back here in a year or two arguing about something else that should be more specifically or better provided. That's really the legislature's rule. And the legislature process is working here. These concerns are raised. The legislature quickly reacted and responded. We believe that was an effective way of dealing with the issue, to be more productive. Mr. Norton raised the issue of notice and the right to be informed. And I don't believe that's an inherent or fundamental issue. When you go back all the way to, again, to Standish versus Kansas Department of Revenue, Supreme Court suggested these advisories to avoid confusion with Miranda. So really, if you look to the statute, and it's been cited over and over again, there's really not even a requirement that the person have to understand the notices when they're given. Furthermore, the statute and the act is to be remedially construed. Getting to the constitutional issues, again, the Fourth Amendment analysis, I've provided argument for why we don't believe that's applicable due to the breath test issue. But, more importantly, the Fourth Amendment analysis also works to not benefit the licensee or the criminal defendant in cases. It's to try to change action. And in this case, there's really nothing improper about the officer. He's doing what he's told. The Department of Revenue is doing what the statute says. So I don't think a remedy here of dismissal of agency action is appropriate. With regard to procedural due process, the cases cited by the appellee, they deal with hearing issues and the assignment of counsel during trial proceedings. And I don't believe that is sufficient to justify the district court's decision. And finally, you get to the issue of substantive due process, which the court, in the context of implied consent actions and reviews, has squarely dealt with in Barnhart versus Kansas Department of Revenue. That's a case from 1988, and it squarely dealt with substantive due process and the sufficiency of implied consent advisories. And in that case, she had a little bit different facts. They ultimately said substantial compliance with the statute is what this court's going to review and what's necessary. And finally, I would point out that if I can dig up my notes, this case has sort of been dealt with in another context, but in a very similar way. In Cuthbertson versus Kansas Department of Revenue, 42 Can-App 2nd, 2009. In that case, the licensee was saying, hey, yeah, you read me the advisories as they were required, but I'm a CDL driver. And there are additional or subsequent consequences to my record or my license, even if I fail the breath test. And in that case, sort of like this one, the licensee come forward and say, hey, you needed more specificity, more granularity, because it may have affected my regular driver's license with 30 days, but my CDL, it effectively disqualified me for a year. And the court simply said in that case, like in this one, we ask that substantial compliance with the statute is sufficient. And there is no constitutional violation in this case that requires dismissal of agency action. Thank you.
Thank you, counsel. We appreciate the arguments here this morning. We'll take the matter under advisement and issue an opinion as quickly as time allows. Have a great day. Court's adjourned on this point.